The first case we'll hear this morning is Sustainability Institute versus Trump, and Mr. Panda, we'll hear from you.
Good morning, Your Honors, and may it please the Court. Sean Jander for the federal government. Plaintiffs contend that the government unlawfully froze or terminated certain grants. They thus sought and received injunctions from the district court requiring the government to reinstate those grants and to continue to make funds available to the plaintiffs pursuant to the terms of those grant agreements. But, as the Supreme Court has recently made clear twice, claims seeking to enforce the government's contractual obligations contained in grant agreements, like those at issue here, have to go to the Court of Federal Claims, not to district court. That principle controls here.
But didn't they also make, well, let me rephrase, didn't one of them, the one person who got to cast the deciding vote, make clear that some types of these claims don't have to go to the Court of Federal Claims? So
in NIH, Your Honor, the Supreme Court did have that kind of split between...
And regardless of whether it was one person, that's actually what the judgment in that case says, right? Like the order that the court issued is consistent with the views of that one person.
Correct, but I don't think that helps the plaintiffs in this case, and I can explain why. So number one, I don't understand the plaintiffs in this case to have actually presented any claims to the district court that are sort of challenging higher level discrete policy decisions.
Sort of, like, maybe in fairness to them, no one really knew until the Supreme Court did what they did that it really mattered which of those two precise buckets were in, right?
It's possible, I guess, that the plaintiffs sort of couldn't have anticipated that, but I don't think that can save the injunction that's actually in front of this court.
Let's say I agree with you on that.
And so, I think in our view, the proper remedy in this case is to vacate the injunctions the district court actually entered, to remand, to dismiss the claims the plaintiffs presented to the court for lack of jurisdiction. I mean, that's without prejudice dismissal if the plaintiffs think they have claims that they could bring in a future suit.
Why would we go further? I mean, I would think we would just if you were granted relief, you would just get a vacation of the preliminary injunction based on the likelihood of success with respect to jurisdiction, and it would be up to the district court then to assess it, wouldn't it?
So I don't think so, Your Honor, because...
for us to, you're suggesting that we actually go further and order dismissal of the underlying case.
So the district court, Your Honor, entered two different injunctions. It entered a final injunction, a permanent injunction, with respect to the APA claims.
But it was still a preliminary injunction, wasn't
it? No.
Is there a permanent injunction?
Yes, Your Honor. Okay. That's
okay.
at JA 8. There's also a preliminary injunction with respect...
Well, that could be reversed if you were getting your relief then, right?
Correct. And I think...
And what was that injunction? What's the distinction between the two injunctions?
So the injunction at JA 8 was entered on the plaintiff's APA claims. That's the permanent injunction, the final judgment. There's a separate injunction entered later in the district court's opinion on the plaintiff's sort of ultra vires or non-statutory review claims. That's a preliminary injunction. There's also actually an earlier injunction entered in the case that I think continues in effect. So there's sort of final judgment on some claims. There's a preliminary injunction on other claims. I think the court would have to assess those injunctions, both of those injunctions. And the court, again, whether it's sort of dismissing the claims that final judgment was entered on, and the plaintiffs could sort of replead different claims if they have different claims. I think the reasoning would probably indicate that the ultra vires claims also have to be dismissed, sort of for the same reasons. But regardless, we're not saying the plaintiffs sort of can't bring or couldn't have brought claims that challenge some higher level policy decision if they were able to sort of identify that decision.
I assume you're familiar with the concept of this when the Supreme Court GVRs a case?
Yes, Your Honor.
I guess what I'm partly trying to figure out is that in this case and in the one that we're hearing right after is like everyone litigated this case before NIH. It turns out that at minimum NIH disrupts what a lot of people thought. Like, why doesn't it make sense to essentially just GVR both of these cases to the respective district courts and say, and to give the plaintiffs and the government a chance to litigate the case and say, why doesn't everyone try this again in light of NIH?
Yes, sir. I mean, I think in this case, we think the claims, the district court didn't have jurisdiction over the claims. And again, if the court says that, whether they're dismissed for lack of jurisdiction, whether the plaintiffs have the chance to amend their complaint and replead sort of different claims with the benefit of NIH.
Or I mean, I know your assertion, and I suspect the government's assertion, and I know from their 28J letter that the government's assertion in the other case is going to be the plaintiffs didn't plead the kind of claim that NIH says survives. But I also imagine the plaintiffs might say, actually, we did. And then then the thought would be, I don't know, shouldn't the district court figure out what they did and did not plead and what they do and don't want to pursue?
Yeah, I think just sort of focusing on this case for the second, I think everything that happened in district court and all three of the district court's injunctions are just so focused on the individual grant.
Well, okay, sorry, but we've pivoted from what happened in district court, and let's say that I probably agree with you on that. But that's not the question of whether you dismiss the whole complaint. The question of whether you dismiss the whole complaint is what's in the complaint, not how the litigation has heretofore proceeded in the district court pre-NIH.
Yes, right. But I think, again, in the complaint, I mean, certainly the prayer for relief is really focused on these particular sort of freezing and terminations.
Wait,
and
okay, JA 150, set aside any actions taken by OMB, EPA, USDA, DOT, and DOJ.
Yeah, I mean, again, that's sort of in the complaint. I think really everything in the complaint, again, it's focused on...
I just read you verbatim from the complaint.
Right, I think...
setting aside an action by OMB does not seem like an action for damages that would have to go to the Court of Federal Claims.
Yeah, again, I think every substantive piece of the complaint really is focused on the individual.
But you agree with me that setting aside an action by OMB, at least prima facie, doesn't sound like the kind of thing that NIH says has to go to the Court of Claims.
I mean, I think, again, if they identified a particular...
you mean like in the next case where the next case, like where the complaint says vacate the no memo?
Yeah, again, I don't want to fight the court too hard on this because I think the sort of practical distinction between sort of dismissing the claims as we understand them without prejudice and sort of vacating the injunctions and letting the plaintiffs replead different claims under the same docket number, I'm not sure is a huge practical distinction.
But only the injunctions are what's on appeal, right?
Correct.
This appeal is not about from a dismissal of the case. We are being asked whether the complaint and the reasoning of the district court can support the injunction ordering the government to pay on these grants, right?
Right. I think that's the primary issue before the court. I mean, there is the sort of one clarification or one wrinkle that at least the one injunction is a permanent injunction that was a sort of a partial final judgment. But again, I don't want to fight the court too hard. We're not saying the plaintiffs have sort of forever lost the opportunity to plead sort of claims that could sort of survive the distinction that NIH draws and that could proceed in district court. We just don't think that they've done that in this case, and we certainly don't think that the injunctions in this case are sort of focused on those kinds of higher level policy determinations that NIH says can proceed in district court. And so all we would ask the court to do is vacate the injunctions that were entered, which I think the Supreme Court has now made clear were improper. And what comes next is not something that I think we care too much about the particulars of as a procedural matter. If there are no other questions on the injunctions, I'm happy to cede the rest of my time.
Is that it?
That is it. Great. Thank you, Your Honor.
All right, thank you. Ms. Hunter?
Good morning, Your Honor. May it please the court. Kim Hunter for the plaintiffs. Your Honor, we agree that the district court injunction, the permanent injunction on plaintiffs' APA claims, was issued prior to the NIH decision and was thus perhaps focused on individual grants when the court could have issued broader ruling on these types of broad level policy claims, which the plaintiffs did in fact plead. At JA 149, it's very clear that we asked for declaratory relief related to executive orders, declaratory judgment about entire programs, not individual grants. Those are the first four parts of the relief that we requested. And then also the set-aside relief that Judge Heitens just cited was also broad relief that we requested under the APA. That is relief we, after we learned during discovery that terminations of these grants had been made at a broad programmatic level, we actually reiterated our request to Judge Gergel for broader relief that wouldn't be focused on our individual grants, but would be focused on that larger grant program. And we would be very happy with a remand on this permanent injunction back to the district court so that Judge Gergel would have the opportunity and the benefit of the NIH decision and to broaden that relief to these high-level policy actions.
So with that, I know this is hypothetical because it's not the question in front of us really, but would that relief look like ordering the government to make grant funds available? If the argument is Congress has ordered you to pay this money to someone, it wouldn't have to be to these particular grantees, but it would have to be available to someone.
I think with regard, this would be an issue that we could brief in the district court. But I think with regard to, if we focus on the EPA grants, where we have this very clear statement in the record at JA 2370, where the assistant administrator is saying, in one day, on February 25th, I terminated an entire program for policy reasons. That is the type of decision that is a high-level programmatic decision that we would want vacated. And then what flows from that, I think, is something that we could brief in the district court. I think as a practical matter, the grantees in this case certainly are eligible for that program and have qualified and maybe the right recipients, but we would be very happy with vacature of that high-level decision. Importantly, though, NIH, as informative as it was on these APA claims, has nothing to say about the constitutional claims at issue in this case, and it's the constitutional
Can I
claims.
ask you about those?
Yes.
The DC Circuit has had a lot of opinions on this topic lately, where they address the same kind of claim that says, the executive is not following a statute, and so that's a constitutional violation, a separation of powers problem. And the DC Circuit has consistently applied Dalton there to say, it's not really a constitutional claim, that's a statutory claim. Would you have us split with the DC Circuit on that?
Well, Your Honor, I do think this issue is still percolating in the DC Circuit. There's certainly been vigorous dissents in all three of those cases, and I think two of them are potentially going en banc. The DC Circuit has also noted it splits from the Ninth Circuit on this issue, so I think your job is to see what the Fourth Circuit has to say about this issue. But our view is that, and this is actually consistent with prior DC Circuit case law in Aiken County and all the way in Supreme Court case law going back to Youngstown, is that this is not an abuse of discretion within a statutory scheme. This is the EPA and the President acting without any statutory authority at all.
But it's not. Okay, so can you help me? I find it's not clear if we have to reach any of this in this case, but I've always just found this conceptually very hard. So it seems to me that two propositions have to be true, but the problem is it creates a real dilemma. So proposition one, it cannot be that every time an executive branch official exercises power that the plaintiff alleges and that a court later concludes was beyond their statutory authority, that they have also violated the Constitution. There has to be room for, they were just wrong about the scope of their statutory authority, but that's not a constitutional violation. That seems like it has to be true. On the other hand, it has to be true that sometimes doing things that you don't have statutory authority to do, I don't know, like say seizing the steel mills, is unconstitutional, that you can't do that. You just literally can't do that, and it violates the... But what I can't figure out is how to draw the line between those two things, right? And it feels to me like, in part, the reason the parties' arguments seem to be talking past each other is your argument focuses on the second scenario, which is there must be some situations where it's unconstitutional. And I think you've got to be right about that. But then the government's like, but okay, but it can't be that every time someone violates a statute, they're violating the Constitution. And when I say violate, I simply mean they understood the statute as giving them more authority than a court later concludes they have, so therefore they went out sort of past their skis of statutory authority. How, again, whether we get there or not is a totally different question, but where do you think the line between those two things is?
Well, wherever the line is, I think we're very
No, I know, but how do I go about answering?
Yes.
I can't decide whether a given case falls on a given side of a line until I understand conceptually where the line is.
Absolutely, Your Honor, and I can say where I think we are over a line.
Yeah.
I don't want
but
to
I need
say
to know
that
where the
other
line,
things
but
would be
but
under the
I
line.
can't assess if you're over the line without knowing where you think the line is.
Well, I'll say this. I think, and our amicus from the Constitutional Accountability Center, I think, talks about this nicely too, as this isn't a place where the court has to get into parsing the statute, and this isn't even a situation where, I think this would be a very different case if EPA had come in and said, we're looking at this statute and we're going to say that oil companies are disadvantaged communities, and we're going to...
In your view, might be they're wrong about that, they're misinterpreting the statute, but that doesn't mean they're acting unconstitutionally by taking that position.
Exactly, and I don't think that is over the line. What happened here was the administrator, following executive orders from the president, came in, and the executive orders say, terminate the Inflation Reduction Act, terminate the IIJA. So that's, first of all, just a straight up, like, terminate something that Congress did. And then the administrator came in, the assistant administrator came in on February 25th and said, we are terminating this entire program. We're not looking at it, we're not redistributing funds, we're just terminating it for policy reasons. And that's what then Judge Kavanaugh said in Aiken County is clearly unconstitutional. And so some of these grant cases are more complicated than ours, and some you have to kind of get under the hood and look at exactly where the compliance is with the grant program. That's not the case here. They made it very easy. Judge Gergel ordered discovery to figure out exactly what was going on, and to their credit, defendants told straight up, we are just eliminating this entire program.
Well, speaking of things that are easy, thankfully I think we have an easier question, right? Because it's just, again, an injunction on the grants that's in front of us, right? And I think we can all agree that neither the Constitution nor the statutes give these particular grantees any right to the money, right? It's the grants, right? The contractual agreement that gives them the right to the funds. Isn't that right?
I don't believe so, Your Honor. And if you think of a different hypothetical where, say, a grantee had a grant and the administration came in and said, we're eliminating this grant because you're Catholic, or we're eliminating your grant because you're Black, that grantee would have a cause of action under the First Amendment or under the Equal Protection Clause. That would be the source of their rights, and their source of their rights to hang on to that grants. It wouldn't be the contractual arrangement, and that's essentially what's happening here. The government did an illegal, unconstitutional thing in terminating these grants at a policy level,
But
and
not
the result
in,
was harm.
even if we accept that theory, that's not in terminating your client's grants, right? It would be in eliminating a program that you say Congress requires the executive to have, right? But if the program exists and funds are available for some grantee, right, that's what the statute entitles them to under your theory, and hypothetically the Constitution if we accept that theory, but not these particular grantees, right? Their rights come from a contract.
Their rights also come from the Constitution, and they have a right that the executive branch will faithfully execute the law, and they have the right that separation of powers will continue to exist. And that's how grant programs have managed to work since the Nixon era. There is an understanding from grantees that the Constitution will function.
Congress waived the government's sovereign immunity for contract claims, but in a pretty limited fashion, right? And they directed these claims to go to a certain court, and only certain remedies are available in that court. And so I think it's kind of, Congress hasn't waived the right to, there's no way around that, to say, well, the statute, unless you can identify somewhere in the statute where these particular grantees are entitled to these funds, right? It's the contract that gives them the right to the particular funds. Even if someone, right, even if Congress has mandated the executive to pay under a certain program to pay these funds to someone.
I don't agree with that analysis, Your Honor. I think they were given the right to that funds, and subsequent to that, they also have the right to separation of powers.
But they weren't given their right to the funds in the statute. Congress didn't give them the right to the funds. Congress conveyed a certain amount, appropriated a certain amount of money for the executive. And the executive is then under the obligation to disperse the monies in accordance with the program. But the only way you get any standing in any of this is because you were a grantee under a contract with the agency. And that contract has a lot of provisions in it, regulations that are incorporated. But what you're trying to do is to avoid the limited waiver of jurisdiction by alleging some overarching constitutional claim that applies almost to every time we're confronted with a governmental violation of a statute.
I don't believe so, Your Honor. I understand the point that initially these grantees got their rights to this money through being granted this money and going through this extensive process. Absolutely correct. And certainly the grantees in this case have standing because of their grants. I will note that not every plaintiff in this case has a finalized grant agreement. Some are sub-grantees, some are still negotiating their grant agreement, so they certainly cannot go to the Court of Federal Claims. But historically, the Court of Federal Claims has not...
They may not have standing to bring the case, but that's not
Well,
for us.
it has not been contested, and I think they do have standing. Historically, the Court of Federal Claims, there have been a lot of grant programs where the Court of Federal Claims and the Federal Circuit has said, this is not appropriate for our review. And the reason is the way that these grant programs work is it's an ongoing relationship between the grantee and the government. It's not a contract where they just say, we guarantee you $10 million. How these grant programs work is there are strings attached, and they only get that money if they continue to do the work. And the Federal Circuit has looked at this time and time again in the Lemmy case, in the MCMS case. They discussed it in the Boaz case, and talk about when there's this type of strings attached relief. That is not relief that you can get from the Court of Federal Claims. Because
So are you arguing that these grants aren't contracts?
We have never thought of them as contracts.
Hasn't that ship kind of sailed because of the Supreme Court's Department of Education and NIH cases?
Well, again, those didn't speak to this particular circumstance, and we haven't pled our claims as relief for contracts. So the relief we sought is this broader level relief that's about the constitutional violations, and then that remedy then flows to the individual grantees.
Yeah, but that's, I guess, that's the whole point of the Megapulse test, right? Is that you to try to figure out if something that's not pled as a contract claim really is one.
That's exactly right. And here, the source of the rights are constitutional rights and statutory rights, not contract rights. And then the relief that we are requesting for the
I don't
Megapulse
follow.
test.
You know, it's so attenuated. You say that your claimant, whose grant was cut off, has a constitutional claim to regulate the separation of powers under the Constitution. It's just such a big jump. I don't see why we don't always address these disputes that come to courts under the most directly applicable source, whether it's a contract or a statute. And if we can resolve a claim under a statute, why would we reach beyond that and say violation of the statute violates the Constitution? I mean, the Constitution creates a structure. Now, if you have something like Youngstown Steel, I'm not even sure that's totally a separation of powers question. That's a question of governmental power, which was extraordinary. But setting that aside, we don't have something of that caliber. What we have here is Congress appropriating money and the executive issuing grants of that appropriated money, and a new administration coming in and saying we're ending those grants. And there are a lot of ways that you can address it. For some reason, I don't know why you want any relief beyond the idea that you reinstate your grantees to the position that they were. It seems to me that's the ultimate claim. Your interest in having a court decide whether the separation of powers and all its history is involved here is almost academic, isn't it?
Respectfully, Your Honor, I do think this is pretty fundamental. This is a situation
It's
where.
very fundamental. It's so fundamental that it applies to everybody in the country. I mean, that's the problem with it.
Well, and it's particularly, the plaintiffs here are particularly harmed. And as the Supreme Court said in Collins v. Yellen, where a party is
But they weren't
aggrieved.
particularly harmed by the separation of powers. They were particularly harmed because their grants were terminated.
Respectfully, they were harmed by the separation of powers, Your Honor. There was a grant program that Congress put into the world through the Inflation Reduction Act with great specificity. The plaintiffs in this case then relied on that grant program and spent years applying for these grants, doing all of the work, working with their communities, getting projects ready, started that work. And then the executive branch came in and said, we are just canceling what Congress told us to do. We are not going to do it. We are going to refuse to do it.
Is this, I'm thinking about the case that the Supreme Court ultimately said the line item veto statute was unconstitutional. And in that case, as I recall, first a member of Congress tried to sue, and the court said, I think 9-0, that person lacked standing because members of Congress don't have an interest in the efficacy of their votes. But then someone who lost some money, I think it was President Clinton, line item vetoed something, and someone who would have gotten money as a result of that line item veto didn't get the money. And that meant they had standing because they lost money they would have gotten but for the separation of powers violation. And then the court said the line item veto violates the Constitution. Is that the basic structure of your argument here?
That's exactly right, Your Honor. And I mean, there has to be some way to enforce the separation of powers. And then Judge Kavanaugh talked about this quite extensively in Aiken County. And this is a very straightforward situation. There's no, unlike some of these other grant cases, there's no doubt about the details here. This is just straight up the executive branch saying, we will not administer
Just like
this grant
to the
program.
extent that Youngstown was a separation of powers case, the steel mill people were mad because someone took their steel mill, which gave them standing. And then they said, because we're mad someone took our steel mill, we get to raise the question that the president absolutely doesn't get to do this thing, even though separation of powers benefits all of us, like someone took our steel mill, which is why we have Article 3 standing. Same basic theory.
Yes, that's exactly right. And I think Justice Barrett confirms this in NIH by saying just because there are grants involved here doesn't mean that all of your claims have to go to the Court of Federal Claims.
What kind of relief are you looking for now in view of NIH? What should we be doing with what's before us under your view?
Yes, with respect to the APA claims and the permanent injunction, we would like you to remand that to Judge Gergel with instruction for him to broaden the relief in keeping with the NIH case. And then with respect to the preliminary injunction, which is reviewed on an abuse of discretion standard, and by the way, this Dalton argument was never raised before Judge Gergel, so he cannot have abused his discretion by not considering it. We would ask that the preliminary injunction remain in place based on our constitutional claims, which are, to the extent they're affected by NIH, I think NIH just shows how they are valid.
Okay, thank you.
Thank you.
All right, Mr. Jonda, you have 4 minutes, yeah.
Thank you, Your Honor. I'd just like to make sort of 3 quick points, if I may. So first, I think the actual disposition of this appeal, the court can sort of reach quite easily. I mean, the injunctions here just look exactly like the sort of injunctions the Supreme Court has said are not appropriate in district court. And the court could say that and not say too much more and let the parties sort of figure out moving forward whether the plaintiffs have other, whether they're constitutional claims, statutory claims, other sorts of claims that could support different relief back in district court. And I think that would be appropriate for the court to do. But second, if the court does feel an obligation or desire to say more, on the Dalton question specifically, I mean, I think this case is exactly like the Global Health Council case that Your Honor referenced in the D.C. Circuit, where the D.C. Circuit actually has now denied en banc review. It was sort of a case brought by grantees challenging what they said was the entire failure to disperse funds under statutory grant programs. They tried to constitutionalize those claims, and the D.C. Circuit just applied Dalton to say, no, like that's a statutory claim, it's not a constitutional claim. It doesn't mean you can't bring it, it doesn't mean you don't necessarily have a claim, but it's a statutory claim subject to the limitations that Congress has placed on judicial review of statutory claims. So I think if the court were to address the Dalton question, it could just follow the D.C. Circuit's lead and say that here. And if the court sort of wanted to say more again about Youngstown, I think Dalton tells you how to think about Youngstown, which is that the only sort of basis of any asserted authority to seize the steel mills was the president's inherent constitutional authority, and so the whole case turned on the Constitution.
But they have a response to that. The response to that would be like, surely Youngstown does not come out completely differently if the president invoked some statute that plainly did not apply and simply asserted that it gave him the authority to steal the steel mills. It can't possibly be that the fundamental nature of the Youngstown litigation would have changed had President Truman just said, I don't know, like, pick a provision in Title 42 and say that gives me the authority, and then the court's like, well, that obviously doesn't give you the authority to do that.
Yeah, and I think President Truman would have lost. I think the fact that the claim is properly, maybe in that circumstance, it would probably be applied as a statutory claim, not a constitutional
That it would be.
claim.
So even if the
I mean, it might
president
be.
identified a transparently inapplicable statute, that means it's not a constitutional claim now, it's only a statutory claim?
I mean, it might well be, and you would lose, I think, that statutory claim.
That just seems very weird
but-
to say that the defendant at its unilateral election can convert a constitutional claim into a statutory claim by citing any provision of the U.S. Code.
I mean, I think even if the court thinks that sort of goes too far, I mean, here, the
I mean,
whole...
here, isn't the question whether the plaintiff is making a statutory or constitutional claim?
It-
I mean, and that's the problem, right? Is the constitutional claim is you didn't follow the statute.
Right, I think that everything just merges in
So
this
it's the
case.
plaintiff who has the authority to decide whether it's a constitutional or a statutory claim. We might look through the constitutional claim and say, look, your constitutional claim is just relying on a statute, right? That's Dalton.
Right, I think in this case, right, you would just look through whatever framing the plaintiffs have, and the whole fight in district court, if the plaintiffs were to bring this sort of claim, and we were to really litigate it, I think would be whether the statutes in this case allow the government to do what the government has done. And that's just a statutory claim. And again, we're not saying they can't bring that claim. We don't think that's the claim that was really presented to or adjudicated by the district court.
But you are saying
at
they
this
can't
point.
bring that claim, right? Because you're saying it's they have to rely on like an ultra vires claim to bring that, and then because there's no specific statement in the statute that they're entitled to these grants, then they would fail that test.
So I think there's two different things, Your Honor. I think on the relief entered by the district court, which focuses on the grant terminations, we think that's precluded by NIH. We think there is a different sort of claim, like the claim that was brought in the Global Health Council case. If the plaintiffs were to say, sort of moving forward, you have decided you're not going to spend any of this money, and the statute requires you to spend it.
Right.
That sort of statutory claim, we think, we think there would be a lot of problems with it in this case.
The money has to be available to someone is a different claim.
Right, it's a
than-
different claim that is not the one that was adjudicated by the district court. And so, we're happy to sort of fight about that in the first instance in district court in this case. But it can't save the injunction that was entered.
I see you have a red light. We'll come down and greet counsel and proceed on to the next case. The next case we'll hear this morning is Solutions and Hometown Connections versus Nome, and Mr. Gerard, we'll hear from you first.
Good morning, Your Honors, and may it please the Court. Bradley Gerard for the nonprofit appellants. DHS shut down an entire congressionally funded program and its position is that no court can consider a challenge to that illegal action by the groups most seriously and irreparably harmed. That can't be. I'll start with the jurisdictional issues. As an initial matter, there are 3 buckets of claims, and the jurisdiction has to be considered separately for each of these claims: APA, separation of powers, and ultravirus. I'll start with the APA. Whether the district court has jurisdiction under the APA or the Court of Federal Claims has jurisdiction under the Tucker Act turns on whether the district court, orders the payment of specific sums due. As DHS concedes in this case, there are no past sums due. As part of the challenge termination, the nonprofits will all be paid for any work that they have done. To the extent that there's any possible money in the future, it comes in the form of reimbursement. So there's no specific sums that could be due in the future under these grants. That amount is indeterminate. The provision of legal services as a part of these grants really shows why. And I'd like to highlight that because I think it's a really important practical point, not merely a conceptual one. As part of these grants, each of the nonprofits has to provide legal services to a host of clients. Now, as we highlight in our brief, once they accept these clients, they have an ethical duty to continue to represent them. Now, as any practicing lawyer knows, once you accept a client, you can't say, this is going to be the exact number of hours that it takes to represent this client. It's something that develops over the scope of the representation. And so under this grant, the nonprofits provide those services, and then they go back to DHS and they seek reimbursement. This is a classic strings attached type of grant that Lummi, as we highlight in our brief.
I think you're leaving out a lot of the facts. I mean, as you opened up your argument, you basically started with the notion that the executive just ended a program without getting into the details, as I understand it. I think the monies here were appropriated to USCIS for use in the Citizenship and Integration Grant Program. And that program was created by the executive, and they went to Congress and asked for some money to fund that program. But it is an executive program to carry out the overall mission that Congress gave it under the USC. The executive created the program. Why couldn't the executive end the program and return the money to Congress? In other words, ending the program was not created by Congress. The program was created by the executive. And the executive could just as well have spent that money directly, but it asked for the way it wanted to discharge it. It created a program, and Congress allocated money for that program. But the executive could just as well say, I don't think that is sufficient. And in this case, the Noam's letter of January basically said she wanted to pause the programs to review them. And then they sent freeze letters to the grants. And finally, which also said the same thing, pause to review them. And then finally in March, they sent termination letters to your clients. But we don't know who else was terminated. You say on information and belief, others were, but that doesn't carry a burden of saying they closed down the whole program. They closed down your 10 grants. They terminated your 10 grants under a program that they created. So these facts have some importance in relation to the overall issues that we're getting, like in the first case, which I think they're quite distinctive in my own view, and I'd be interested in hearing you address that aspect.
Yes, Your Honor, and I think there's 2 important points in response. One is factual, the other is legal. As to the factual matter, the termination of CIGP, DHS has never said that CIGP was not terminated. It's never said, oh, we actually want to spend this money on other parts of this.
They don't need to explain that to you. Basically, the record shows that they paused the programs to review them, and following those pause notices, first by the Secretary and then later by individually to each grant, they terminated the 10 plaintiffs' grants.
Well, Your Honor.
And they said basically they didn't have all this background that you're positing.
Well, Your Honor, I want to push back a little bit. I think the termination email, DHS included every CIGP grant recipient. So it wasn't just an email that went to our 10 clients, it went to every CIGP grant
Where's that
recipient.
show in the record?
I can point, I'll have to dig up a pin site from the complaint.
Well, I saw the complaint. The complaint says on information and belief, you believe everybody was terminated.
And the government has never pushed back on that.
We're on a preliminary injunction, and you have to show that basically they never said they're ending the program. What they said, they're pausing it and reviewing it. And they did review it, and they ended 10 grants here. And so my question is, it goes back, it's a multi-step question, but the main one is the program is not congressionally protected.
Well,
the program was funded at the request of the agency, but it was created by the agency.
and I'm glad you went back to the main point, because I think that's really important. It's true that the program was created by the agency, and I think DHS's argument might be a lot stronger here prior to 2019. Prior to 2019, the way that Congress appropriated funds was generally to USCIS for immigration integration programs. In 2019, Congress ratified CIGP specifically. It started in the Appropriations Acts, naming that the money goes to CIGP. And so at that moment, that became a program that that DHS, that the Secretary just does not have the power to cancel.
I don't understand, it doesn't follow. If an executive creates a program, which they did in this case, and then they go to Congress and said, we'd like some money to fund that program, Congress said, okay, and they use the word is available for that program, it seems to me, and there's no other strings attached, it seems to me that doesn't say, Congress isn't saying you have to have that program.
Well, Your Honor, I think we're getting a little bit into the merits of the separation of powers argument
Well,
here.
it's fairly important because this case, the district court denied the injunction and reviewed all this, and I think this creates some hurdles that you have to meet, and then you can't just address the fact that the executive disagreed with Congress and tried to end a program created by Congress.
Well, Your Honor, I think I'll stick with the separation of powers for right now to boil this down to the kind of the most simple understanding, and I think this makes this a lot easier than the prior case where government counsel said, look, there are statutes. The minute that there's a statute, this becomes a problem for the plaintiffs. You can't have a separation of powers claim. The fact that here we only have CIGP mandated by Congress through an Appropriations Act highlights.
It doesn't mandate it. It's important that you stick with what is in the record. It doesn't help the argument when it provokes a response that you're overstating your case. Congress never mandated it. Congress said these $25 million or whatever the sum was available to this program, which had been created by the agency and for which the agency requested funding.
Your Honor, I think I'd be happy to go back and do some extra briefing on this if this would be helpful. I think over the last 50 years, this is the way that Congress in appropriations acts in the language that it mandates that the executive spend money. It will say this much money is available for this when Congress wants to give discretion to the executive and knows how to do it. And that's been true throughout history.
In times past, agencies have not spent all the money and have returned it to the Treasury. The Supreme Court building was built with an appropriation, and money was returned to the Treasury. At the end, they didn't spend it all.
And I think there might be some tough cases where it gets a little closer, where it's not spending of every cent, but I think this one is an easy case for that, where Congress appropriates money for a program, and DHS says, we are no longer running this program.
Can we talk about the actual injunction you requested, though? The injunction you requested you didn't ask the district court to order the executive to make funds available, use funds for this program. You asked the district court to undo the grant terminations, so to order the executive to pay these particular grants. right?
I disagree, Your Honor, respectfully. I think if I can point you to J56, the
I'm
prayer
looking at JA 581, your proposed order granting motion for preliminary relief.
And what we have asked at the highest level is the court to vacate and set aside the termination of CIGP.
Not in your PI, you didn't.
I believe that I would have to look at, I don't have the specific language for the PI proposed order, but I think if you look at our briefs, if you look at the prayer for relief in the complaint, you look at the arguments that we've made, it's been clear.
The Supreme Court has told us that that Justice Gorsuch said, an order vacating the government's decision to terminate grants is in every meaningful sense an order requiring the government to pay those funds, right?
I understand.
So you
it.
requested the district court to order the vacature of the terminations.
Yes, so this, obviously the proposed order came before NIH, and I think we might have worded it a little bit differently.
So the proposed order is J 581, is that correct?
I believe so. I can,
Yeah, I think you should. Do it. Because I'm seeing, I agree that you do that, but it basically also said, well, it says, would enjoin the government from pausing, freezing, impeding, or blocking grants on the basis of the January 28th, 2025 memorandum issued by Defendant Secretary Noem or the February 4th, 2004, 2025 letter from the Department. So, is that the part that you would word differently now? Because what you're asking to do is to pause, freeze, impede, or block on the basis of. Is that the part that you would phrase differently in light of NIH?
yes, I think so. The first, so I'm happy to have this now in front of me. The first request in the proposed order is order that defendants shall not dismantle the CIGP program, including by. So,
Well, you described in your brief that you don't really have a dismantling claim, that it's 3 acts, right? You said dismantling is the memo where the secretary said we are immediately freezing funds, then the letters informing the grantees that their funds had been frozen, and then the terminations, right? That's the dismantling.
yes, I think altogether
Okay.
it shows that that DHS has, again, and I don't think DHS says to the contrary, that this is a termination of CIGP. The first thing we ask for is an order that the termination be vacated. Now, post NIH, to Judge Heighten's question, I think the way we might word it is set aside, vacate the termination of CIGP, and from there,
Or the no memo.
or the no memo, and we could let the agency.
The no memo, it just said effective immediately, these funds are paused, right?
Yes, but it's
So that did the freezing.
that did the freezing, and then it was the termination implemented that permanently.
It's not like a policy memo saying like, henceforth, it shall be against the policy of this office to fund this particular program. I'm instructing my subordinates to go forth and, find grants that need to be, terminated and report back to me. Instead, she said, effective immediately, funds are frozen.
Yes, and I think that actually puts us more in the Justice Barrett concurrence high-level agency action that
I
can
would
be
have
reviewed.
thought it puts you less in it, because she drew a distinction. She said, setting aside the agency policy memo wouldn't necessarily cause the grants to be paid or not paid. She said those two don't necessarily flow legally from each other in that case. Here, it seems like they're one and the same.
I disagree, Your Honor, and I think I'd like to zoom out a little bit and go back to Bowen, which both NIH and California recognized as still good law. And I think it's important because all these cases read together, especially in light of Justice Barrett's concurrence, mean that the APA allows injunctive relief that might result in some indeterminate amount of money in the future. The Tucker Act applies to orders to pay specified sums of money now, and in those cases, the reinstate these grants, that's just effectively an order to pay the specified sum of money now. This case falls
But the Supreme Court has told us that applies to claims on contracts, not just sums that are past due, sums that are due now, that it applies to claims on contracts.
Well, Your Honor, I don't think the Supreme Court has said that any claim on contract goes to the Court of Federal Claims. I don't think the court can be.
You don't think so?
I don't think it can be read to have totally overruled Bowen. And I think
does not provide the district court with jurisdiction to adjudicate claims based on grants?
I think the gravamen there is really claims for the payment of money. And that's what a lot of the grant cases are. That's what,
They said, or to order relief designed to enforce any obligation to pay money pursuant to those grants.
I think,
Two
again,
things.
I don't read NIH as making that broad I mean, that would be a sea change in the law to say the Tucker Act, which gives very specific jurisdiction over very specific types of claims, which are breach of contract claims. It doesn't mean that anything that involves a contract goes to
No, it means any claim on a contract.
Exactly, and I think this is where Megapulse comes in.
Right.
Where then we look to see, okay, well, what is the relief that is available? What's the relief that's appropriate? And what are the source of the rights? And to the relief that's available and appropriate, as I've said, the case law makes clear that there is no contract claim in the Court of Federal Claims with this kind of situation. There's no past due sums. And Lummi, the Federal Circuit, makes clear, when we're talking about this kind of strings attached grant, where the only way we can determine what money might be due in the future is by letting that go forward, we don't, the Court of Federal Claims has no jurisdiction to consider that, because that's not a breach of contract claim. That is not a claim that is ordering the repayment of some kind of past sums.
Where did the district court abuse its discretion?
Well, I think the district court got the law wrong.
In what respect?
Well, I think I have 20 seconds left, and I think focusing on the APA specifically, one of the first places that it got it wrong was to say that because the grants are the source of the relationship, that's the source of the legal rights. And that's simply not the case under any of this case law, whether that's Megapulse or Crowley or
But the source of your standing could be different than the source of the legal right.
That's exactly right, Your Honor. I see my time is up.
Okay. All right, Ms. Dillon?
Good morning, Your Honors, and may it please the Court. My name is Jessica Dillon, and I represent the federal government in this appeal. The District Court properly concluded that this grant termination case belongs in the Court of Federal Claims. These claims are no different from the claims that the Supreme Court found must be brought in the Court of Federal Claims in the NIH and Department of Education v. California cases. The same fundamental facts are involved. The agency directed a mass termination of grants, and the grantees have brought claims challenging those terminations and seek reinstatement of their grants. In this case, the plaintiffs try to sidestep that rule in two ways. The first, by framing their claims as directed at the dismantling of the grant program writ large, and second, by framing their claims in constitutional and ultra-various theories. The District Court correctly rejected both of these efforts. First, the plaintiffs framed their claim as being directed not at the individual terminations of their grants, but at some abstract, high-level agency decision to terminate the program.
And maybe they lose that claim, but I don't understand why the Supreme Court's decision in NIH doesn't say that's at least a claim you're allowed to make.
So in NIH, and I think this might have been what Judge Rushing was referring to in Mr. Gerard's argument, that the guidance documents were policy memoranda that set forth ongoing agency policy that NIH wouldn't fund certain categories of research.
Sure.
So the plaintiffs could seek in district court prospective relief against the enforcement of these policies. And Justice Barrett explained, importantly, that there was a legal distinction between the challenge to the grant terminations because vacating the guidance wouldn't reinstate the grants. There are no policy memoranda here. There is no distinction between the termination of the grant program and the terminations of the grants themselves. And termination of the program, according to the plaintiffs, is made up of the agency actions freezing and then terminating the grants. And the relief sought is to vacate and set aside those grant terminations, which is precisely the relief that the Supreme Court held the district court lacked jurisdiction.
I just might be missing this. This is different categorically, so much so that we should just rule for you on this from NIH. How? I genuinely don't get, I mean, I understand your view is that they're wrong. Your view is that their view that the no memo is really just your view is that you can't separate them. Your view is that there's no real policy in the memo. But that's just an argument the plaintiffs are wrong, not an argument that the district court lacks jurisdiction to hear that argument.
So, I think that the framing as being dismantling the program, this decision to dismantle the program, they're saying that decision was three things: the no memorandum, the freeze letters, and then the termination letters. Those,
Right.
So if those are the agency actions that are at play, they don't even argue that there's a decision.
But in
to
fairness,
terminate.
everyone litigated this case before the district court, before NIH, right? And I don't blame anyone. I don't blame the government. I don't blame the plaintiffs. I don't blame the district court. But no one was litigating this case in light of NIH before the district court. So of course, the way people litigated this case before the district court doesn't reflect a decision in NIH that hadn't been made yet.
But so I understand that, but I do think that this actually, in a lot of ways, reflects what the plaintiffs would try to do I think they are trying to fit this into the NIH guidance. And there's just no agency decision that is a discrete agency action that they point to. They don't even argue that.
And again, that's an argument that they're wrong. That's an argument that their claim would fail. It's not an argument the district court doesn't have jurisdiction to hear the claim.
So the argument is that the reframing is not meaningful. Is not that if you look at the apply megapulse, the source of their rights and the relief sought, all point to this being a claim designed to enforce a contractual obligation, and that falls squarely within NIH. And I think it might help to show what a claim might look like that perhaps would fit more closely with NIH, and that would be a claim where there's a final discrete agency action setting forth a policy that to close a program that is statutorily mandated to exist. And a plaintiff could challenge that policy, seek to set aside that policy for the future, such that whatever decisions the agency were to make about grants going forward, they couldn't rely on that policy. That would be more like NIH, but that bears no resemblance to this case because there is no policy like that. The agency
What is
action-
the no memo if not a policy declaration? Why does the Secretary of Homeland Security issue memos if it's not a policy document?
So
You get memos from the Attorney General. Those are policy documents, right? Like when the Attorney, I used to work at DOJ. When memorandum to everyone who works from DOJ from the Attorney General, it would have never once occurred to me that is not a policy document.
So the no memorandum, all it did was instruct that disbursements to nonprofits related to immigration grants are on hold pending review.
Yes, and that seems like pretty obviously a policy decision. And again, maybe it's a good decision, maybe it's a bad policy decision, maybe it's a legal policy decision, maybe it's an illegal policy decision. But it seems bizarre to say that's not a policy document.
So a few things. I think the freeze letters sort of piggybacked off of the no memorandum and paused the disbursements of grants.
Right, they implemented the policy announced by the Secretary of Homeland Security.
So I think the problem with that is that now that pending review is over. The grants were reviewed, they were terminated, and so there's really no.
Well, that's an argument the plaintiffs have a mootness problem if they want to challenge the no memorandum. But again, that's not an argument that they can't do, that they couldn't ever do it. It's maybe an argument that the claim is now moot.
So we made that argument that
But that's not the ground the district court ruled for you on.
I'm sorry?
That's not the ground the district court ruled for you on, is it? And again, it's not the district court. I don't blame the district court for this. The district court was acting before NIH. I think the district court just took a blunderbuss approach and said, you can't bring any of these challenges to any of these things. None of these challenges at any time were valid. Go away. And that was before NIH. I'm not blaming the district court for that in any way. But that's how the district court didn't say, well, maybe they would have had a valid claim to the no memo, but that claim is now moot. That is not the ground on which the district court ruled in your favor.
I agree with you. That the district court didn't say anything about the mootness of the no memorandum. But I think the fact still remains that if that's what the plaintiffs were seeking, were just to overturn the no memorandum and not do anything about the terminations,
No.
That would have no effect.
Hold on. The claim that Justice Barrett said in NIH that they can bring to the district court, everyone knows why the plaintiffs are actually bringing that claim. They hope and aspire and goal, but like, we don't assess whether someone can bring a claim based on our assessments, even if plausible, what the person ultimately hopes to get from it, right? I mean, that's the argument that the other 8 justices in NIH probably all agreed on, which is that the splitting of these claims in the way that Justice Barrett said we should do doesn't make a lot of sense, and a point in which the court, I think, was, 8-1. Unfortunately, the 1 in this case was more than the 8 from their perspective. But the plaintiffs, and the claims that were allowed to proceed in district court in NIH, the reason the plaintiffs are pursuing those claims are, at least in part, because they wanted things to continue to happen in the world, right? Or at least it seems very plausible that's the reason they would do them.
So I suppose that's why a plaintiff would bring any claim.
Sure, because
That doesn't
they
mean-
think it will help them somehow, in some way, right? People don't pursue litigation for the heck of it.
Can we talk about the injunction that the district court denied? I mean, that's what's on appeal, right?
Yes.
If the district court had issued an injunction vacating the secretary's memo, what would that have done? Would it have given the plaintiffs any relief?
So, Your Honor, I don't believe it would, because the terminations,
Their grants
Are
were
the-
terminated,
right, so there's.
not by the memo.
Exactly, and right, the no memorandum did not tell DHS you must eliminate all grant programs having to do with immigration. It just put those programs on hold, or those grants on hold. And so that it would be impossible. The only agency actions here are the termination letters. They superseded the no memorandum and the freeze letters to the extent that they were even final, which we would.
Yeah, to the extent we're talking about practical relief in the real world, which is what an injunction would be, we'd have to set aside the terminations, right?
Right. So, Your Honors, I want to briefly address, just on the Tucker Act issue, a secondary aspect of this case, which is that there are 2 plaintiffs whose grant agreements were obligated in 2024. And those 2024 grant agreements include a specific disclaimer of any entitlement to money damages. And in the federal circuit, there is a recognized exception to Tucker Act jurisdiction where a contract expressly disavows money damages. And it's for this reason that the government did not press the jurisdictional argument with respect to these 2 plaintiffs in the court below. However, the district court still properly denied the preliminary injunction as to these 2 plaintiffs because plaintiffs' reframing of their claims away from the terminations of their individual grants and now broadly challenging how the program is being run created a separate problem. It turned this case into a sweeping program-wide attack against the agency.
I thought the court only ruled on the 23 grants. I didn't think those other ones were before us.
No, that was in there were 2 decisions on the preliminary injunction. The first, you're correct. The second, Judge Grigsby also ruled that there was no discrete agency action, and then her third ruling was that there was no, and this goes to Judge Niemeyer's point earlier, that there's no statutory mandate here and nothing that requires the grant program, and so there was no conceivable separation of powers ulteriors claim. And so the district court correctly found that the plaintiffs had failed to demonstrate a likelihood of success on the merits, both because of the jurisdictional bar that I just described with respect to the vast majority of the plaintiffs with the 2023 grants, and as to all of the plaintiffs because their claims did not identify any discrete agency action that is reviewable under the APA. And the other way that the plaintiffs tried to avoid Court of Federal Claims jurisdiction is by dressing up their claims as constitutional and asserting ultra-vires theories. And once again, the artful pleading does not alter the underlying contract-based nature of their claims. And even if the court were to treat them as distinct claims, they still lack merit because fundamentally the agency acted squarely within its statutory and regulatory authority, as well as under the grants themselves, which not only do not prohibit termination of the grants, they include express termination clauses and regulations that provide for it. Plaintiff's separation of powers and ultra vires claims rely upon alleged violations of congressional appropriations, but as the district court correctly found, the grant terminations did not violate the Appropriations Act, nor did they violate any other statute or regulation identified by plaintiffs. So if there are no further
All right.
questions.
Thank you, Mrs. Dillon. All right,
Thank
Mr.
you.
Droy.
Thank you, Your Honors. Just a few points quickly. As to the fiscal year 2024 grantees, the DHS raises a new argument today that it didn't make. In its brief, what it said was, well, the claims by the fiscal year 2024 grantees are claims that are for broad injunctive relief. And I think that's an important concession here because it's the same exact claims brought by the fiscal year 23 grantees, requiring the same exact analysis, requiring the same exact relief. Now, to the relief, to Judge Rushing's question about practical relief in the real world, I think this helps to show why this case can fit squarely under Justice Barrett's concurrence in NIH. And I think that the ordering the vacatur if it's an APA, if it's APA relief, ordering an injunction if it's equitable relief under the separation of powers, the result is the same, that it's setting aside and vacating the termination of the CIGP program. And I think what that means specifically is a practical point, is really it's a question for the district court and the agency in the first place, but I can point to something in the uniform guidance that shows how this could play out in a way that the government could achieve its policy ends. The nonprofits could continue to carry out their programs. So 200-340A2 in the uniform guidance, for example, it allows partial termination of grants, but the parties have to negotiate the terms. And so DHS can go back and say, okay, well, under our changed policies, we want to renegotiate the terms of the grants. We'll continue the grants with you, but we really want you to focus over here to carry out these policies. That's something that could be done. And I also think the fact that the nonprofits would have the ability to reapply for the grants in the future, that matters. And point the court to JA 505, JA 535 to 36, specifically plaintiff ESLC. They've done these, they've been a part of the grant program since 2009, and they've stated that they plan to apply in the future. And the relief of setting aside and vacating the termination of the grant program would not only allow them to continue doing the work that they're already on the hook for with this legal representation, but would also allow them to reapply for it in the future. And so I think that just gets to one of the practical points. And then as a final point, I just want to highlight that I do think it's important to separate the merits and the jurisdictional questions in this case, and I think it's easy for them to get mixed up. I think under Megapulse, especially looking at the relief that would be appropriate here, and the fact that the Court of Federal Claims simply could not grant the nonprofit any relief at all, shows why this is squarely not a contract claim. Thank you very much.
All right, thank you. We'll come down, Greek Council, and take a short break. courtroom. It means we're a cozier group. All right, we've got this next case, the United States versus Evans, and I guess we start with Mr. Zirkin.
May it please the court, Gerald Zirkin representing Nelson Evans. Mr. Evans was charged with traveling in interstate commerce with the intent to commit murder for hire, or using interstate commerce facilities or the mail to do with the same intent, and with conspiracy to do the same. The murder is not an element of the offense and need not even be attempted for the crime to be completed. The Eighth Circuit in U.S. v. Delpit laid out the elements of the crime very carefully. The crime is complete when the defendant travels interstate or uses interstate commerce facilities with the requisite intent. The court, in that case, reversed aiding and abetting conviction because the defendant's assistance to the hitman occurred after the interstate travel had occurred. So the interstate travel happened, the crime was complete, she identified targets at that point, and so she couldn't aid and abet because the crime had been completed. Here, the government had to prove that Mr. Evans entered Virginia from North Carolina with the intent to commit not just a murder, but specifically a murder for hire. The government relies on a number of circumstances in the evidence. First, that Shipman and Evans had phone calls before they traveled from Greensboro, North Carolina to Norfolk. But there is no evidence as to what was discussed in those calls. They may have just discussed how they would meet, or it may have had nothing to do with the trip at all. We have no content to those conversations. Secondly, they rely on the fact that they traveled together from Greensboro to Norfolk. Again, no evidence as to what they discussed or when they discussed what they discussed. The government invites the court to assume that they discussed a murder for hire. And importantly, the court would have to assume that they discussed committing not just a murder, but specifically a murder for hire. And that they discussed it before they reached the Virginia-North Carolina border. Next, they rely on the fact that they drove by Ms. Bond's home. That tells us nothing, however, about when Mr. Evans learned about the killing, if he did. Fourth, they say that Mr. Evans did not express surprise when Shipman mentioned the murder when they were riding with Alvon Davis. They don't attribute any statements to Mr. Evans during that drive. Maybe he thought it was unwise to react in front of Davis, whom he did not know.
So, okay, that's the first thing you said that unquestionably to me seems to violate the standard of review in a sufficiency challenge. Why isn't it reasonable to say if someone, if one person says to a second person in the presence of a third, by the way, we're gonna do a murder, and the third person doesn't go, wait, what are you talking about? This is the first I'm ever hearing about the fact that we're gonna murder anybody, that you can infer that's because person two already knew about the murder. That seems like a reasonable inference.
Well, except for the fact that, number one, he did not know of Mr. Davis. Mr. Davis was a member of a gang. My client was not.
These are
a
great
member
arguments
of that gang.
about maybe why I shouldn't draw that inference, but it's not an argument that it's unreasonable as a matter of law to draw that inference.
Well, I don't think you can draw. I don't think you can assume what is in his head for his reasons to not react.
And yet the criminal law requires us to do that all the time, to make assessments about what people are in their head based on how they act. That's like literally what every criminal case involves almost.
So let's assume for a moment, I'll grant that, and let's assume that that's the case. However, that doesn't tell us anything about when he learned about the murder. We still have the exact same problem. Did he learn it before he traveled in interstate commerce? And we don't know the answer to that. So if that's true, it doesn't help the government's case. And of course, it also doesn't address the question of murder for hire as opposed to murder. Mr. Evans lied to law enforcement, they say, when he was questioned 4 years after the murder. And even if that does evidence consciousness of guilt for the killing of Miss Bond, that's a far cry from its evidencing consciousness of guilt for traveling in interstate commerce to commit a murder for hire. For his lies to evidence that, he would have to know, first of all, that that was, in fact, an offense. And they rely on Mr. Evans, the fact that Mr. Evans killed Miss Bond. Even if that was true, it did not provide evidence of his having the intent to commit not just a murder, but a murder for hire when he crossed from North Carolina into Virginia. I thought my
I think
time is up.
yeah, your red light's on.
Yes, sir. Thank you.
Okay, we'll hear from Mrs. Carl.
May it please the court, I represent appellant Caleb Shipman. The Confrontation Clause prohibits the admission of a non-testifying defendant's statements at trial if they are testimonial and if they are facially incriminating of a second defendant. There's no issue of testimonial here. The United States has conceded that. The issue is facially incriminating, and as the Supreme Court and this court have ruled, the crux of whether a statement is facially incriminating is not what a defendant said he did, but the degree to which he implicates another defendant in that conduct. In this case, the district court erred by reversing that. The district court focused on the conduct being described by the non-testifying defendant and not on the fact that it implicated Mr. Shipman.
Have you been able to identify a case for what our standard of review is for whether something was facially incriminating or not?
No, I cited a standard of review in my brief for Bruton issues, but I believe the government cites the more appropriate case for the standard of review here.
But what is it? So, because I could see, like, on the one hand, whether it's facially incriminating seems like a fact-inflected question that we would normally defer to district court judges on. But on the other hand, the Supreme Court has told us that things like reasonableness and probable cause are reviewed de novo. So I mean that as a sincere question. Like, I genuinely think it's not immediately obvious what the standard of review should be of whether or not, when a district court says something is or isn't facially incriminating, what is our standard of review of that question?
Well, here it would be de novo because here the district court just got the law wrong. The court misinterpreted this court's decision.
So they made an error of law, is the argument? Okay.
Correct. The district court misinterpreted the Supreme Court's decision in Richardson v. Marsh and this court's decision in Benson. Because what he did is he focused on the conduct of what was being said. But he looked at those statements in isolation. This misconstrues the Supreme Court's case in Richardson v. Marsh and this court's holding in United States v. Benson. In Benson, the only testimonial statement at issue in that case was a statement where a non-testifying defendant said he and others took a truck to a residence. Now, following the definition of facially incriminating advanced by the district court and the United States here in this case, the issue in Benson should have been whether the act of taking that truck with others to a different location was incriminating. The focus would have been on the conduct. But that's not the issue when you are evaluating Bruton and the Confrontation Clause. The issue in Benson was not about the conduct. It was about whether it implicated a co-defendant, Mr. Brown, who owned the truck. And this court held that it didn't implicate Mr. Brown because it didn't implicate Mr. Brown in the actual conduct that was being described by the non-testifying defendant. This is in sharp contrast to the non-testifying defendant's statements in this case, in which he repeatedly and explicitly not only named Mr. Shipman by name, but he discussed multiple times traveling to a location. It was the only time that the two of them had traveled there together, that they stayed in a certain location. In fact, he identified my client, Mr. Shipman, in a video where no one else could identify him. And we know that this conduct was incriminating as to Mr. Evans because Mr. Evans' statements were admitted at trial. How can those statements be incriminating as to Mr. Evans at trial sufficiently?
I thought the question that the precedent asks is not just, is it incriminating, but is it facially incriminating or inferentially? incriminating? Don't we have cases saying, you know, the only way it's facially incriminating is if it's the very first thing that's spoken at trial and everyone would know that that incriminates him in the crime?
That is a quote out of Benson, but the issue.
Versus inferentially, which means the jury has to piece together other pieces of evidence to see why it's incriminating to have been at the gas station at a certain time.
That is correct, Your Honor. That is a quote from this court's Benson decision. But the issue, though, that you can take those quotes, but that's not the evaluation the court is making in those decisions. Any piece of evidence looked at in isolation is not incriminating.
Sure it is.
And
If someone says, he did it, he shot him, that's facially incriminating,
that
right?
is absolutely facially incriminating. And if we followed the rule of the definition of facially incriminating advanced by the government, those would be the only statements that would be prohibited from admission at trial. Statements where a non-testifying defendant does explicitly admits to the crime, but we
So
have
what's
partial.
the line between facially and inferentially incriminating? I mean, the court has said there's a line, that those things are different, and one is okay and one's not. So what is it?
Well, you're talking about a standard in which you focus on how incriminating that conduct is. The standard, it's a Bruton issue. It's a confrontation clause issue. The focus is, does that statement implicate another defendant?
Well, no,
So
it definitely isn't, does it implicate? Because that would mean that every statement
Right.
that arguably implicates. Your red light is on. Can I ask you, I have a different question about, Judge Niemeyer, can I ask a different
Oh,
question?
sure.
I have a double jeopardy question. Let me posit that I actually think you have quite a good double jeopardy argument, but I think that your client in particular has a very big problem. Where in the record did your client ask the district court to merge counts 7 and 8?
May I look at the
Sure.
briefing?
I think your client might be the one who didn't. But if I'm wrong, I genuinely want to know that if I'm wrong.
So we have in the brief that Mr. Shipman moved to dismiss count 7 as multiplicitous to count 8, so a merger argument. And that's at JA 152 to 158. That's the briefing. And that was
My bad. I think I'm confusing.
I'm
perhaps
Shipman,
two-
not Simpson.
There we go.
The other
That's the
ex-defendant.
mistake. Well, so Mr. Simpson's lawyer should be prepared for me to ask where they preserved their double jeopardy argument.
But I believe Mr. Shipman has.
Sorry,
that.
you were absolutely right in correctly deducing that I messed up two similarly named defendants. I'm sorry.
Your Honor, it's a 32-volume JA, so thank you. If there are no more questions.
Thank you very much, Ms.
Thank you very much, Your Honor.
All right. Okay, Mr. Dinkin, I guess we hear from you next.
I was checking to make sure we preserved it. May it please the court, my name is William Dinkin and I represent the appellant Landis Jackson. We raised a number of issues in our brief, but I'd like to focus on the sufficiency of the evidence to convict Mr. Jackson of being a member of a continuing criminal enterprise. And specifically, we contend that there was insufficient evidence to convict him because there was no evidence that he was a manager, organizer, or supervisor of 5 or more people.
What was the evidence about Mr. Jackson? I thought there was evidence suggesting that he was Simpson's right-hand man. He'd also gone to Mexico later and followed the same tracks and to get cocaine, and they operated together very
Right.
closely. It seemed like there was evidence of that. Is that right?
Yeah, right. So the government in their closing argument said he was the vice president. That's the closing, right? And that's kind of the
I'm talking
overall.
about the evidence.
but that kind of summarizes about as good as it gets for them. There was one witness, I believe, and maybe 2, that used the term right-hand man. And those are kind of conclusory labels.
That's a pretty understandable term. I mean, everybody, I think, understands what a person's right-hand man. He's there helping him, has a lot of presence, consults with him, helps him, carries things out. They do things together.
Right.
Isn't that what a right-hand man does?
Well, he could be right-hand man, as in they're good friends together, and they go to football games and they hang out with each other's families.
That's not a right-hand man because they're not going about doing anything.
No.
A right-hand man has to help carry out functions.
What I was really looking at is where's the evidence, not the conclusory label, but the evidence in the record that he was his right-hand man. And the evidence in this
What
case.
evidence would you want other than somebody saying, I observed them together and he was his right-hand man?
Well, I would like some specifics. I think that rather than having a jury speculate as to what that means, it's fair to insist, frankly, that the jury get actual evidence as to what acts were taken to show that Mr. Jackson was an manager, a supervisor,
Wasn't there a lot
or
of
an organizer.
communications between Simpson and Jackson?
There were a ton of communications. There's no question about it. The evidence really kind of divides the workforce, if you will, into two camps. And the first camp is all the folks who worked for Simpson. These are people who were under surveillance. These were people where there were poll cams filming their activity. These are people who were followed, making deliveries of drugs and delivery of money. These are people who testified at trial. And not anyone that testified at trial in the Simpson camp of those folks who were all identified said, Jackson, I was under Jackson's control. I took directions from Jackson. He organized us. There was nothing there. The government really finds their support and their tie-in on these very transitory comments that are made on the intercepted calls between Jackson and Simpson, where Jackson is talking about various people that he only has nicknames. It's Dre or Tink or High Point Dude, things like that. And what's really missing is everything that you see for the Simpson camp. We don't have surveillance of those people. We've got no controlled buys, no observations. They didn't testify. We don't even know who they are. And so what we're left with is the government asking a jury to speculate whether, and it's not that they exist or not. The question is, was Jackson controlling them? Was he managing them? Which this court has said under U.S. v. Butler, proof of supervisory or managerial relationship requires a showing of some degree of control by the defendant over the other persons. And that's what's missing here. We have just names and just references to people with nothing else. And in that absence, the jury's left to speculate. I
thought some of those intercepted communications where he mentioned the people, he was mentioning instructing them to do things, right?
I don't know if he was instructing them to do things. He's referencing that, I think.
He's apprising Simpson of, well, this went wrong with this guy, but I told this other guy to do this, and here's how we're going to sort it out.
He's saying that things went wrong on occasion, correct. But, the question here is control. And it's not just whether they exist. And it's not even whether these folks are selling drugs for Jackson. The question is does he have some degree of control over them, or did he organize them? And that's what we don't have.
Okay.
Am I over? I'm over.
Yeah, the red light's on.
All right.
You have some rebuttal, though, I see.
Okay,
Yeah.
thank you.
All right, thank you, Mr. Jenkins. All right, Mrs. Franklin-Best.
Yes, thank you, Your Honors. I'm here, I represent Mr. Simpson. To answer Judge Hayton's question, it does not appear that counsel did join that motion. I would argue, though, however, for the sake of judicial economy, that if he is going to receive the benefit of this, that the court go ahead and do so now, instead of waiting for this to arise by way of a 2255 motion. Because my time is short, I thought I would argue the search issue in this case, although of course I am happy to answer any other questions. The GPS tracker that was placed on Mr. Simpson's car was not supported by probable cause, and thus it was improper. First, the government challenges Mr. Simpson's standing, and respectfully, he did have standing. There's no doubt that Mr. Simpson had permission to drive the car, and as other courts have found, rejecting a defendant's ability to make Fourth Amendment challenges for technical violations would completely eviscerate Fourth Amendment protections.
Let me ask you about I found that to be a closer question in this case. I think the question might be, would he have standing if he had a girlfriend hire the car as a front to avoid being stuck with the car being imputed to him, coupled with the fact that he also didn't have a driver's license, and so that his use of the car could almost be treated as an unauthorized or a stolen property, so as the exception under Byrd.
Well, and I understand, and you know, the.
But I mean, you passed over the standing. I found the standing somewhat tough. I thought maybe there isn't standing.
Well, I do believe, I mean, so, you know, the government sort of takes as a premise in this case that Ms. Ware was kind of a straw purchaser, right? I mean, that the whole purpose of her renting this car was so that he could use this for this drug trafficking. But, you know, that was more of an assumption than an actual, you know, than proven.
Well, there's quite a bit of evidence to support it. I mean, he did several that way, and he had his own cars. And so the inference can be drawn as the reason he's using rental cars is to escape connection and detection, and which I must say we see in almost every drug case anyway.
But we do have in this case also, I mean, additional evidence to show that he was a bit of a car guy. I mean, he had, you know, a Porsche, he had a Corvette, I mean, so.
Yeah, but the question is whether the particular car involved in this case, which he had rented through his girlfriend in order to avoid detection in a circumstance where
yes, Your Honor, I
might
mean.
not have been an authorized use.
So, but I would argue, you know, when we had sort of the testimony of Agent Cobbler, for example, who testified that he was unaware of any narcotics activity that actually happened with this Impala. So, I mean, there's evidence to show that there was no drug trafficking from that particular car. You know, I would go back to sort of the language of Byrd that says that, you know, few protections are as essential to individual liberty as the right to be free from unreasonable searches and seizures. I mean, I think
we
this
agree
court,
with that. Everybody
exactly.
does, right?
And so I think, you know, to the extent that this is a close case, that we would err on the side of finding, you know, a reasonable expectation of privacy and giving him sort of the Fourth Amendment protections.
So let's say you get over that. Why is the warrant invalid? I mean, there's just a feeling like we spent a whole bunch of time in cases like Jones saying, I feel like I've seen cell phone cases like this too. Like in Jones we say, if you want to put a tracker on someone's car, you got to get a warrant. And the government's like, cool, we got a warrant. And then the argument is, the warrant's invalid because it's a general warrant, it can't possibly be valid. It's like, surely no one in Jones thought the answer was, you got to get a warrant, and that warrant's necessarily invalid.
No, absolutely. I mean, but, you know, I think what happened in this particular case, I think that, you know, this kind of came on the end of a previous case, the Sandoval case. And I think what happened here is that having disrupted that particular drug trafficking organization, I mean, I think that law enforcement here, frankly, got a little sloppy. They got a little maybe too self-confident. I mean, I think when you look at the language of the affidavit,
some of your arguments for why this warrant is invalid strike me as an argument that all GPS tracking warrants are invalid. And I guess the one thing I know from Jones is I don't think it's plausible for me to say that all GPS warrant tracking warrants are invalid.
well, and I think that's accurate, but I mean, I think when you're going to have a GPS warrant, for example, I mean, there still need to be some limitations. I mean, I don't think that every GPS
Well,
warrant.
the limitation is
can be
probable cause.
It is probable cause.
And if the warrant has probable cause, then the warrant issues, right?
And there was no probable cause here, Your Honor. I mean, that is our argument. I mean, you know, there was a confidential informant who was used as sort of the basis of a lot of this information. No reliability. The basis of the veracity and the reliability of that CS was not sufficiently outlined in the affidavit. He had not provided any information to them in the past. No information that was corroborated tended to show unlawful conduct. I mean, that particular CS, you know, identified the car.
But where do it was issued by a judicial officer, wasn't it?
I mean, it was.
So then how do you get around Leon?
Yeah.
Let's assume you somehow win that issue. How do you get around Leon?
We have, well, first of all, I mean, the affidavit was spatially inadequate to support the search. It failed to state with particularity the place to be searched, but also the information that was presented at that truncated Frank's hearing militates against allowing a good faith defense in this case. For example, you know, Cobbler statement in the warrant that the 2017 Impala had been used for criminal activity, but then during his testimony in December of 2022 that it was not used for narcotics distribution. He also, in one of the PIN register warrant, completely omitted the July 5th GPS tracker order. He also, lack of having engaged in any alternative investigative procedures. He offered mere boilerplate and attempting to meet the necessity
You would really
requirement.
have these officers second guessing they pitch what they think is probable cause. They put it in an affidavit, and an independent, neutral judicial officer looks at it and said, I think there's probable cause to issue the warrant. And they issue it. The officer's supposed to say, no, Judge, you shouldn't have issued it. I mean, they take the warrant and they do exactly what they're instructed to do by the law, and now we're going back and second guessing whether the judge got it right.
May I respond to that, Your
Sure,
Honor? I see my
please.
time is out.
Please, yes.
I mean, under that analysis, then there would never be an improper warrant. I mean,
Well,
so this is
we
how
have Frank's, the whole Frank's doctrine. We have a bunch of doctrines that police these things, but we also have a process, and the process in this case was followed.
Well- Well, yes and no, because I would push back on that a bit and say, Mr. Simpson asked for Frank's hearing in this particular case and was not
Well, there was
allowed
no
to have
evidence.
one.
Was there evidence of deliberate lying in the warrant?
He was not allowed to fully explore that particular issue. I mean, I think that there is enough in this record.
He has a burden to even set forth enough to justify the Frank's hearing.
And respectfully, he did so.
Yeah,
I mean,
okay.
so my time is
All
up.
right.
So,
Thank you. All right, we now move over to the other side, and Mr. Honold. You have a lot of defendants to speak about.
Yes, Your Honor. Good morning, and may it please the court. Daniel Honold for the United States. Of the many issues that
Could we start with double jeopardy?
Yes, Your Honor.
Okay, so you know how the Blockberger test works. Here's
Yes.
the following question that I've not been able to figure out the answer to. Please describe a set of facts that constitute murder for hire that do not constitute conspiracy to commit murder.
Yes, Your Honor. One situation that I've been able to think of is when the other participant, for example, the person who is arranging for the purported hit, is a government agent.
That's not conspiracy because you can't conspire with a government agent?
That's correct. That's the Hackley case. We don't cite it for that proposition in our brief, but that case is in our brief. And then the person goes on to travel.
Well, what if the conspiracy is a difference? You have a leader of a mafia, and he directs his lieutenant to hire a hitman to take out an opponent. The conspiracy is the agreement to go hire somebody and hit. The actually hiring is another conspiracy, but it's distinct. You can't rely on the same conduct in the hiring. You have to have a separate conspiracy to commit the crime, the whole crime. And I don't see that violates our normal conspiracy versus the conduct, underlying conduct crime.
Yes, Your Honor, and we do start from the point
The
that
element is the other new agreement to commit the whole crime. You can't use an element of the crime you're going to commit to be the conspiracy. You got to use a different conspiracy, and the completed conduct is the differential. I mean, there's two aspects. Both crimes require acts different from the other under Blockberger.
I think in general, Your Honor, yes, that's right.
I mean, I don't think you have to get to a sort of a very narrow possibility that, one of the persons is a federal agent. It's just got to be a conspiracy to commit crime for hire. So the conspiracy element can't be the hiring part. It's got to be a conspiracy to commit that crime, and that requires additional conduct. Now, the hiring the person is the element of the crime, and that also is a conspiracy within that crime. But I don't think one satisfies the other.
That being said, Your Honor, in all candor to the court, that individual may also be guilty of substantive murder for hire in that he causes someone to travel in interstate commerce with the intent that that murder be committed. So I don't know that that gets us out of that situation. My hypothetical was basically to respond to the narrow point that their basically sole argument on this is that whenever you prove consideration, you've effectively proved a conspiracy such that conspiracy is a lesser included offense, and that would be one situation where that's just not true. It's true.
Wait, so just so I can walk through this hypothetical. The version then is, I can't be guilty of conspiracy to commit murder in that situation because my co-conspirator is a government agent and you're representing that I can't conspire with a government agent, even if I don't know he's a government agent, but that I can provide consideration to the government agent to ask him to do something that he's definitely not going to do because he's a government agent.
Yes, Your Honor.
Okay.
Yes.
What's the best authority for that proposition?
Well, Your Honor, I was thinking of the reverse situation in which the government agent is the promisor. In that situation,
Sorry, the murderer or the hirer? It'll help me. Is the government agent the person who says, I want you to kill someone, but I don't really want you to kill someone because, of course, I don't want you? Or is the government agent the one who says he's going to kill someone, but is actually never actually going to kill someone?
the former. And in that situation, the person who would be the murderer can still travel in interstate commerce or use an interstate facility in receipt of the promise of pecuniary value. That can
But
still
that's okay, and it's not your fault at all because I phrased the question this way. But under Blockberger, the question is not, describe a factual. Under Blockberger, it's that each requires proof of a fact, the other does not. So what is the fact that conspiracy requires proof of? And so you're going to say agreement that murder for hire does not?
So what I'll say is, when you
I guess what I'm trying to just figure out is, maybe I'll phrase it this differently. So the argument is about consideration is the element of murder for hire. What is your definition of consideration that doesn't include an agreement between two people?
It's not that consideration doesn't involve an agreement between two people. It's that there may be factual scenarios in which proof of a conspiracy is not going to match up perfectly with consideration in that.
But the Blockberger question is whether each requires proof of an element, the other does not. That's the Blockberger definition, right?
I believe so, Your Honor.
So
yes.
what's the element that conspiracy to commit murder requires that solicitation, that murder for hire does not?
The element of conspiracy, well,
And I say that, and so I read, there's all these cases you cite. You said there's a mountain of authority. With all respect to all those opinions, I read every single one of them, and every single one of them just repeats the obviously true proposition that conspiracy to commit a crime and committing the crime are not the same thing. Let's assume that I 1,000% agree with that proposition. But what none of them do is say, but how does that map on to the actual crime of murder for hire? And how does the crime of murder for hire require proof of an element that conspiracy does not? And I don't think a single one of the opinions that you cite in your brief actually engages with that question in any meaningful way. They just recite the general rule. There's a difference between the substantive offense and the conspiracy offense.
I hear you. I think that's not an unfair characterization of that case law. I think what I'll say is, and I haven't done all the research to figure this out, I think there's a split of authority on whether 1958 conspiracy has an overt act requirement, and in the situation in which a conspiracy has an overt act requirement, it's theoretically possible to prove substantive murder for hire by use of traveling in interstate commerce or using an interstate facility in a way that would not constitute an overt act. I'm just not sure if in this particular jurisdiction or generally it's the government's position that overt act is
So
required.
obviously I'm building a lot of assumptions into the question I'm about to ask you. You're not conceding anything by answering the question I'm about to ask you. Assume for the sake of argument that with regard to at least one defendant we disagree with you, what would be the remedy? If we think that 7 and 8 are duplicative and they violate the double jeopardy clause, at least as applied to the defendants who properly raised that issue, what would be the remedy for that?
I think it would just be the vacatur of what Your Honors would have to hold as the lesser included offense, which would, I think, be the conspiracy count.
But as a practical and that you'd probably have to resentence the defendants, but skipping to the end, realistically, we're all probably going to get the same sentences?
I don't know that you would even need to remand for resentencing. They
I'm
receive
not sure you need
concurrent
to
life sentence.
resentence if it's two concurrent offenses and one is reversed. I think you have to vacate that sentence, but is there authority that says we have to resentence?
I think it's within the court's discretion as to the scope of the remand that's required. I mean, it could play into the I'm forgetting the term right now, but the sentencing
Is
package
that-
doctrine.
That's what I was thinking of too, is the sentencing package,
packaging.
the
Yeah.
sentencing package
I think in
doctrine.
a situation like this where you're merging a lesser included offense into a greater included offense where both of them have concurrent life sentences, the sentencing package doctrine is not going to apply. So you would just vacate.
So can I turn you then to this, it pains my heart because courts keep using these words when it's the standing question, it hurts, it breaks my heart to call that a standing doctrine because it's obviously not standing. I guess I'll say, so I know that the mere fact that it's not your rental car means you don't have Fourth Amendment, that doesn't prevent you from having Fourth Amendment standing. And then there's the Second Circuit opinion that the government asked us to endorse that says, yeah, okay, not your rental car is not enough, but not your rental car plus not licensed driver? I don't understand. I mean, I don't mean this. I literally don't understand why that fact would possibly change the Fourth Amendment standing analysis.
I think the place to look for that, Your Honor, is Byrd, which says that the reasonable expectation of privacy analysis has a lot to do with the property rights and society's reasonable expectation of privacy that is
But we've
imposed
already
in certain
crossed that bridge when we said it doesn't have to be my rental car, and I don't understand why whether I'm a licensed driver or not affects that analysis.
It affects it in the following way. As opposed to, you know, say a car that you own outright. An owner was going to have a larger bundle of property rights in that car. They can own it, they can put it in their garage, they can fix it up, they can tweak it, they can show it off, they can do whatever they want. Your bundle of rights with respect to a rental car is much narrower. You really only have it for a brief period of time to drive. You can't do maintenance on it, you can't fix it up, you can't paint it, you can't do any of that stuff. It's really just for driving on the public roads under the terms of that agreement. And if you, as an individual, don't have the thing that is required, a license, to do the one real thing that you can do with a rental car, that impacts.
So this is how you would distinguish because I was thinking of the example of like my hypothetical 15-year-old child who owns a car that they're not allowed to drive. Surely they have a reasonable expectation of privacy. Like if the car is parked outside, on the street outside my house, and the government agent breaks into the car owned by my hypothetical 15-year-old child, like they have standing under the Fourth Amendment to challenge you doing that, even though they don't have a driver's license, right?
I think that's right, and the differentiation there is what, you know, your child can do with that car that you've given them. And so I think that's the additive function of those two aspects. That's why they make sense to go together. And so we would ask this court to follow Lyle and Hammond from the Seventh Circuit, which predates Byrd, but which survives Byrd.
I think there's a split among the circuits on whether the unauthorized license is enough. It seems to me in some circumstances it might be, in some others it might not be. But I think what it seems would be unanimous among the circuits is if you consider not only unauthorized license, but the fact that the arrangement was reached in order to protect the defendant from being traced, used for an unauthorized purpose of drug dealing. It seemed to me at that point the authorization to use the car is similar to having stolen a car. And of course, the court has agreed, the Byrd court has agreed that a stolen car, you don't have a right to privacy.
Yes, Your Honor, and that's the possibility that Byrd left open in its remand. And of course, the defendant in Byrd, I believe, had a valid license.
Did you make a Byrd exception subterfuge argument here?
We did not.
I was really looking for it because it's the one the Supreme Court left open.
Yes, Your Honor, we did not. I wouldn't say that we made it in precisely those terms, so we haven't put it forth. Here we are really relying on the unauthorized driver from the rental agreement plus the lack of a valid license.
And can I flip the hypo differently? I'm just trying to make sure, because your argument, so I think you'd also probably agree with me that let's say the Impala is not a rental and that Simpson actually owns it, but he still has a suspended license. He clearly has Fourth Amendment standing then, right?
Yes.
So it's just sort of weird that saying there are two conditions, neither one of which alone deprives you of Fourth Amendment standing, but somehow when I put them together, they magically deprive you of Fourth Amendment standing. It just seems real weird to me.
I understand the court's hesitation, but again, I think it goes back to Byrd. It's, what are the property interests at play here? What are society's reasonable expectations that we impose on certain situations? And here, I think society recognizes that there is a big difference between the rights that you have with respect to a rental car and the rights that you have with respect to a car that you own outright or that you're leasing or that's in your name.
Well, the Supreme Court has defined the right to be the lawful, you have lawful possession. And if you steal a vehicle, you don't have lawful possession, and you have no rights to argue that they can't search the vehicle. The rub comes as to what lawful possession means, and some courts think that you would not have lawful possession without a driver's license because the rental company wouldn't lease it to you. But some other courts have hypothesized factual circumstances where there may be, even in that circumstance, some kind of, I don't know how they do that. But it seems to me if you add the subterfuge, which is in this case, it's hard for him to claim that he's protected because of his possessory interest in that vehicle.
Yes, Your Honor, we agree with that sentiment in the sense that
Because the possessory interest can't just be a possessory interest, it has to be a lawful possessory interest.
it does, and that's why that unauthorized driver aspect is a major component of this analysis.
Would it be lawful for him to possess any car, not just a rental car? He doesn't have a driver's license. Can he lawfully possess a car?
I think so. I think he just
Right.
can't operate it.
Right. The only thing that makes him not able to operate the car without a driver's license is, or not lawful to have it without a driver's license, is the rental agreement, right? I thought
don't
that's
know that
what you
it's-
had just said. You said it was the rental agreement. They would never rent a car if you didn't have a driver's license.
Yes, but if I heard Your Honor correctly about unlawful, I don't know that it's a crime in North Carolina to possess the rental car being
Right.
an unauthorized driver.
Right.
So it's not that it's, but taking a step back, the reasonable
So
expectation of
how is
privacy.
Byrd satisfied then if it, how is it
Because-
unlawful?
Reasonable expectation of privacy doesn't turn on
Why
whether
would
the
it
conduct is
have to break
unlawful.
the law? I mean, the idea of the rental is whether now the rental company has a fee simple possession of that car and they rent it out only to certain people. And it seems to me you don't get possession if you would not have qualified to get part of the rental company's fee simple interest in that car.
But hasn't Byrd told us that that's not, I mean, if you're not the person they rent it to and you're not allowed to drive it under the rental agreement, but that you still can have a right to privacy, right? That's what Byrd is about.
That is correct under the facts of Byrd, where you've got someone who's got a lawful operator's license. What's the unlawful aspect here is not his, sitting behind the wheel in his driveway. What's unlawful about it is that he's operating it on the roads.
Okay, so let me
without a
change the
license.
hypo again, and now he's not illegally driving the car. So let's say someone rents the Chevy, parks it in front of Simpson's house, gives him permission to use it. Simpson has a suspended license, same as here, leaves the car parked in the street, stores things in the trunk. The government installs a GPS tracking device while it's sitting on the street. Does he have Fourth Amendment standing then?
I think so, Your Honor. And here, we didn't.
Wait,
place
you
the-
think he does then?
Well, we didn't place the GPS tracker.
No,
in.
of course I know that's a hypothetical, but you think he would have Fourth Amendment standing in that situation?
Yes, Your Honor. I think.
Then why doesn't that give the whole ballgame away? Because now you've conceded that a guy who doesn't own the car and who doesn't have a valid driver's license sometimes has Fourth Amendment standing.
Oh, I'm sorry. He does not have Fourth Amendment standing.
Why?
Because
It's totally lawful for it to be parked in the street in front of his house. He's not driving the car. In my hypo, he is not illegally driving this car.
So I think the main thing to take away from this is that the reasonable expectation of privacy analysis does not turn on whether at a particular moment you are committing a crime.
It also might suggest it doesn't turn on whether I have a valid driver's license or not.
I think it does, Your Honor, because that goes to the property aspect of it. Remember, he's still got the same bundle of rights, the same limited bundle of rights in that rental car.
I can
whether
own
it's
things
sitting-
that it's illegal for me to use. Can't they? People can definitely own. So, I mean, in a former life, I worked on a case involving, for example, a guy who'd been convicted of a crime that made it illegal for under federal law to possess a firearm. And the question was whether or not he could transfer that fire. This is Henderson versus United States, I think. Whether he could transfer the firearm to someone else. And the government's like, no, he can't. And the court's like, no, that's wrong. It's illegal for him to possess the firearm. It doesn't mean it's illegal for him to own the firearm. And as long as it's legal for him to own the firearm, he can give it to someone else.
That all may be true, but that doesn't strike me as a Fourth Amendment reasonable expectation of privacy.
No, but it does suggest that there's a difference between owning something and being authorized, like legally entitled to use it in a certain way.
Right. I think maybe I can try to elucidate it in this way. It's not a crime to visit a friend in their house, but you don't have a reasonable expectation of privacy in their house. It doesn't really matter whether you're committing a crime when you go in their house. You just don't have a reasonable expectation of privacy. there, because
But
that's-
to continue with that example, I do if I'm an overnight guest.
yes. But this is
Even
not,
though I have no property interest in my friend's house, even though my friend could kick me out at an instant, the minute I'm an overnight guest, maybe not. Many, if not most, overnight guests do have Fourth Amendment standing.
that is generally true, Your Honor, and that's a situation in which society has recognized that people have a reasonable expectation of privacy in that situation. This is a very different situation where you are being an unauthorized user of a rental car, which I think society, the average person would recognize, as opposed to being an overnight guest in someone's house that they own or lawfully rent.
It really feels like we're just relitigating the case the government already lost in the Supreme Court.
Well, Mr. Byrd did have a valid driver's license, and I think that does change the landscape here. But even if this court found that Mr. Simpson had a reasonable expectation of privacy, the affidavit here provided adequate probable cause for the officers to place that GPS warrant. I think there are three kind of sub-factors to this. The first is the confidential informant that formed part of it. The other is staleness, and then the third is the general warrant aspect that Your Honor was addressing with my colleague. So I'll just take them in order, and I realize we're kind of getting down to time. I'm happy to turn to anything else at any time. As to the confidential informant, this was a known informant that had been working with the officers for the previous 18 months. This is not an anonymous tipster. This is someone who had come in and debriefed with the officers multiple times. You can get that from just looking within the four corners of the warrant. He's corroborated in multiple ways, including by indicating the extent of the Sandoval operation, which then leads to an arrest and a takedown and the recovery of multiple kilos of drugs, the naming of the cars, the Corvette and the Porsche, and several other facts along those lines. So this confidential informant, CRS-1, as he's noted in the affidavit, fits comfortably within this court's existing case law on the reliability of known informants. That's what we're dealing with here. As to the staleness, as the district court, I think, correctly found, Mr. Simpson was a major drug trafficker through, undisputedly, up until the arrest of Mr. Sandoval in early June of 2016. The question is, in that intervening time period between then and July of 2017, what's the evidence that he has desisted, or what's the evidence, put another way, that he's continuing to engage in suspicious activity? It's twofold. One, it's the sheer size of the operation. He's moving multiple millions of dollars and dozens, if not hundreds, of kilograms of cocaine up until June of 2016. In the district court's experience, and as mentioned in Encarnacion, someone of that volume is not going to simply put up shop and go home when their one supplier is arrested. They go find somebody else. And then Simpson is continuing to use these rental cars, which from the 10th Circuit Williams case, and I think any reasonable magistrate would be entitled to infer, that's continued suspicious activity that makes it much less stale. Finally, as to the generality of the warrant, I think with respect to my friend, we're looking through the wrong end of the telescope on the generality point. It's quite clear that this warrant is highly particularized. The affidavit is for a specific vehicle denoted by VIN, license plate, state, license plate number, make, model, year, color. Anything that you would want to describe a car is included in this affidavit, and it's for a specific period of time. That's about as particularized as you could want to be.
What's the standard of review for us to, when there's not a Frank's situation, for us to review a warrant issued by a judicial officer?
I believe the question of whether there's adequate probable cause is a question of law that's reviewed de novo. But I think under any standard of review, the probable cause here is going to survive, and it's especially going to survive under the much more heightened standard of the binom Leon good faith analysis. So again, in terms of generality, I think, as Judge Heitens was alluding to, Jones is going to come out differently if their theory is correct. The Supreme Court.
It would be like after Carpenter saying, turns out you can't ever actually get a warrant for a cell phone. It's like, well, then that was a lot of trouble to say that you've got to get warrants to search cell phones.
Absolutely correct, Your Honor. I think it's common understanding that when you're collecting location information for a particularized object, such as a particular car or a particular cell phone number, those things can travel interstate, can travel throughout the country, and you're going to be able to collect that location information about it wherever it goes in the country, and that doesn't make something general, that just makes it broad. Unless there are any further questions on the suppression issues, I'll turn to the sufficiency claims. I heard one by my colleague for Mr. Evans and one by my colleague for Mr. Jackson. I'll start with Mr. Evans. The intent to commit murder for hire before engaging in interstate travel for Mr. Evans. We've presented at trial significant circumstantial evidence that any reasonable jury could use to infer that he knew the purpose of his trip to Norfolk before he took it from North Carolina. We've got the relationship between Evans and Shipman. They were roommates, they were friends. They then moved apart from each other, but there's a phone call, a 14-minute phone call just days before the murder. We don't have the contents of that, but in the light of all the other evidence, any reasonable jury could infer that the purpose of that extremely long phone call for them was about going there to commit this murder. They then go, and as Judge Heitens pointed out, in his discussion with Alvon Davis, with Mr. Evans there, they're discussing in explicit detail how this is going to go. Mr. Shipman's going to be the driver, Mr. Evans is going to be the shooter, and Mr. Evans doesn't say a word about it. That is really strong evidence that he knew the purpose of this trip before he ever set foot out of North Carolina. And then, of course, we've got the implausible story that he told to the FBI, further evincing his consciousness of guilt. Turning to Mr. Jackson, his challenge to
Can I take you back to your argument on the double jeopardy that someone has pointed out to me? If your argument on that is right, that like you can't conspire with the government, why doesn't that suggest the Supreme Court's decision in Rutledge is wrong? Because wouldn't that argument suggest that the Supreme Court was wrong to say there was a double jeopardy problem in Rutledge? This is the continuing criminal enterprise and conspiracy to distribute drugs.
Yes, 846 conspiracies will merge into CCE under 848 under Rutledge. I don't
like
know.
your whole like you can't conspire with the government element. That's
Right.
that, which sounds like plausible. And I've been trying to figure out what if anything is wrong with it. But then the thing I've stumbled upon is why wouldn't that suggest Rutledge is wrong?
Off the top of my head, I'd have to think back through Rutledge and the textual analysis that I engaged
Rutledge
in.
is really an overlap with the same conduct. The enterprise and the conspiracy are really part of the same conduct. I do not think that precludes at all a conspiracy to commit murder for hire, because the persons outside of the murder for hire crime would be the conspirators. And the person who directs it and even funds it would have to be separately proved. You also have to prove the contract to hire, which is inherently a conspiracy. But that is a distinct conspiracy under the crime, distinct element. One is the plan and agreement to commit that crime, and the other is the crime itself, which includes the hiring. I just don't see a problem with that myself. Under Rutledge, I think it's not even, Rutledge had a totally different issue. It was the same overlapping conduct.
Rutledge has an in-concert element that is what incorporates the conspiracy aspect of the 846 conspiracy. As I stand here right now, I'm
Sure.
not able to think through like the
I understand.
implications for that, and I apologize.
No, it's like a fourth level question out of order.
Okay, thank you. So
Could you just address briefly, we got a few minutes, address briefly Shipman's sufficiency claim?
Shipman's sufficiency claim, Your Honor? Yes, Your Honor, I'm happy to. So Shipman raises a number of sufficiency claims. He's got a challenge to
Basically that he was aware of the conspiracy.
Yes, this is the challenge I think Your Honor is adverting to his conviction on count 4, which is the
Yes.
Drug murder conspiracy aspect of it. So I think we start from the point that I think, as he acknowledges in his brief at page 80, he's aware that there's a conspiracy when this is happening. I think the questions are, did the government present sufficient evidence that he knew that this was a conspiracy for cocaine? And did he know that this was a conspiracy for at least 5 kilograms of cocaine? And I think, at least as to the first, and probably as to both, at 4097, when he's discussing in explicit detail with Alvon Davis why he's there to do what he's there to do, it's because someone ran off on the plug, can't pay, I'm
What's,
here.
what's the definition of a plug?
A plug is the person, this is from Mario Love, and also I believe from Alvon Davis. The plug is the person that has the connection to the cocaine. This is a person who has a significant source of supply, and Mario Love's testimony specifically ties it to cocaine. So that's where, you know, you can pair those up and get that understanding from that. And then as to the size of it, this is a hit contract for $10,000 per victim. He's got a pre-existing relationship with Jackson, so a reasonable jury could infer that he knows the extent of Jackson's activities. Jackson hires Shipman to go do this for $10,000 per victim, and he knows that he's doing it on behalf of a plug. This is somebody who's a repeat drug player and a major source of supply. So the idea that no reasonable jury could infer that it was for at least 5 kilograms, that he knew that, I think just doesn't fit with the evidence that we presented in this case. So that's his claim on count 4. I'm happy to address anything else for Shipman's sufficiency. In the absence of those questions, I will turn to Mr. Jackson's CCE conviction under 848. I think we start with Butler and Ricks. The supervisor, leader, organizer requirement for 848E is not a terribly high requirement under those cases. You don't need to directly supervise any of the 5 people. Any management position is enough so long as this organization consists of 5 people. And I don't hear my friend to meaningfully dispute that this organization does in fact consist of 5 people. We have not only the people that directly testified, Crouch, Love, Wallington, Tate, McCrimmon, Ware, Farland, Crawford. We also have all the people that Mr. Jackson is referring to on the wire calls with Simpson. And I think it's really important to step back and remember, these are calls clandestinely recorded by the government between the president of a drug organization and the vice president of a drug organization. There's no reason to think that Mr. Jackson is somehow fabricating the existence of these people or what he's doing with them. It's the VP reporting his activities to the president. And so, you know, I think despite my friend's arguments here, we have really solid evidence that he's directly organizing, supervising, and managing at least those 5 people, even if he's not directly supervising the people that physically testified at trial. And I'm not aware of any case law for the proposition that you have to directly know the government names of the other people that you're supervising. I'm really coming down to time here. I did not have an opportunity yet to talk about Bruton. I'm happy to rest on the briefs with that. But this is Mr. Shipman's claim that...
Well, I mean, can I just ask you the same question I asked your colleague on the other side? Do you know of a case that says what the standard of review is of a district court's decision about whether something is facially incriminating?
I don't. I didn't look for that, like, specific question. I would just say, I think for purposes of this argument, since it hasn't been briefed up, you can assume that it's, you know, de novo review. You can look at the transcripts of the interview between Agent Terry and Mr. Evans, and you can see they're not facially incriminating in any way. Your Honor, if I could just have a brief moment to finish the response.
You can finish your answer.
Thank you. You look at those, it's about Mr. Evans and Mr. Shipman taking a less than 24-hour trip to Portsmouth, not Norfolk, to Portsmouth, pumping gas there, you know, seeing a friend, and then going home. An outright denial of having any involvement in the murder, and that's just not going to be facially incriminatory in a way that needs to be redacted. I would point this court to Benson and the 5th and 9th Circuit cases cited in there, Lage and McKell, for that proposition. Situations in which you do not need to redact, where the content of what is being challenged is not itself facially incriminatory. You only need to redact when the statements are otherwise facially incriminatory as to the co-defendant, who's not allowed to cross-examine. And therefore, Bruton is not implicated. I see I'm over my time. I'm happy to answer any questions about any of the other issues, and if not, we'd ask that Your Honors affirm.
All right, thank you.
Thank you.
All right, now we come back to Mr. Zirkin.
Thank you, Your Honor. Very briefly, there's no evidence that ties Mr. Evans to the idea of consideration. A discussion about consideration, the fact of consideration, until he's back in Greensboro and he is counting money. That's the first time it comes up. That is insufficient to establish that prior to his going on this trip and crossing the border and engaging in interstate commerce, that he in interstate travel, that he in fact had, that knew this was a murder for hire. Shipment could have had any number of reasons that he wanted somebody killed. Assuming you had the 14-minute phone call, that the total assumption that what they're doing is talking about doing a murder, it doesn't mean it's necessarily a murder for hire. He could have said, I've got problems in Norfolk. I need you to come do this murder to help me out of that. That doesn't mean that it's a murder for hire. And it has to be specifically, that he knew that this was a murder for hire before he went, crossed the border from North Carolina to Virginia. Thank you.
Thank you. All right, Ms. Carlton.
I want to address your question about the sufficiency of the evidence regarding Mr. Shipman in count 4, which is committing the murder during the course of drug trafficking. There was no evidence at trial that Mr. Shipman was engaged in drug trafficking. And as this court has ruled in prior...
Well, I guess the question I'm trying to figure out is the government presented evidence that he was being brought in at that point to commit the murder for hire or participate in whatever, and he knows what's going on and what he's helping in the conspiracy and willingly does it. In other words, the question is, do you actually need acts actually in the furtherance of a drug transaction? Or is it enough if you further the interests of the conspiracy, which is the government's theory? In other words, he knows of the conspiracy, he knows what's going on, and he's now doing some enforcement work for the conspiracy. Is that enough?
Well, the furthering the drug conspiracy, that is a separate section of the statute, which was not charged here. To further the interests of its CCE is what the statute...
I mean, they have to link him to the conspiracy, don't they?
So for section 3 of the statute, yes, Your Honor, they would have to link him to the conspiracy. He'd have to be engaged in the conspiracy. But there's no evidence that he was engaged in a drug trafficking conspiracy.
Well, the drug trafficking conspiracy included enforcement, doesn't it? Somebody steals drugs, somebody has to enforce it.
Well, here...
Somebody is threatening. I mean, there are a lot of aspects of drug trafficking conspiracy that don't involve actually participating in a transaction.
But this court has ruled in Burgos that you have to reach agreement to join the conspiracy.
Yeah, sure.
You have to have the mental state of wanting to further the interests of the conspiracy, and there's no evidence of that here.
Okay.
That's what's lacking here is whether there's actions or not. It's like if you were the drug dealer, Your Honor, and you had hired someone to improve the security of your trap house. May I finish the analogy?
Yeah, well, I understand it. I understand your
Okay,
point. Yeah.
thank you very much.
Yeah, thank you. All right, I guess, Mr. Dinkin, you have a couple minutes.
Regarding the sufficiency of the evidence for Mr. Jackson's involvement in the CCE, my colleague, I think correctly indicates that under Butler, control does not need to be direct. But there has to be evidence of control, and that's what we don't have, or have some type of supervision, organization, or management. And on the Simpson side of the operation, there's no evidence that Jackson had any involvement with those folks. And some of them even said so themselves. As to the other folks, the ones that are referenced, I think as Judge Rushing pointed out, there's discussions about problems with drugs. I think it was drug quality that they were talking about. But what wasn't there was any evidence that Mr. Jackson was in control of these folks. And if he was selling them drugs and they were doing what they wanted, then that's not control. Likewise, management or some type of organization. And so I think that's the distinction, and that's the evidence that's missing here. And so for those reasons, we don't think that Jackson was part of the CCE.
All right, thank you. All right, Ms. Franklin Best.
Thank you, Your Honors. So the government did not advance the lower court below this Byrd subterfuge argument that was discussed earlier. Mr. Simpson was not allowed to introduce any evidence on that point, and so it would be sort of fundamentally unfair to kind of use that as a basis for rejecting his claim. I think that when you look at kind of the evolution of these cases in the Fourth Amendment context, from Jones to Carpenter, when you look at the numerous concurrences in Chattree, you know, sort of a rejection of kind of this possessory interest argument that I understand the government to have advanced up here. You know, it is reasonable to believe that you have an expectation of privacy in a car that you have permission to use, and if there's some sort of a violation.
The court used the word lawful, and everybody's trying to, a lawful possession, and it doesn't focus on whether the activity is lawful, but it focuses on whether the possession is lawful. And it's a degree of property interest that the court's focusing on, so that if you own the car, it doesn't matter whether you have a driver's license or whether you have protection at your car and you expect privacy there. Mm-hmm. If you're a rental car, you have less, because you're authorized by the rental company within the parameters of the remedy. But if you're not even the renter, now you start getting marginal on your possession, and the Supreme Court has indicated that there are lawful possessions under that. So now you go a little further, and you don't have a driver's license, which is not a question of unlawfulness, but it's a question of whether the rental company implicitly gave you authority, possessory authority. And then if you can keep going on, so the whole question comes down to the legitimacy of his claim to possession. And even if the car is parked in front of the house, he doesn't have possessory interest in the trunk or whatever, unless he lawfully has some possessory interest, I think.
And may I respond?
I think that's what I understand Byrd to be saying.
If I may respond to that.
Please.
Because on the record that we have here, we have, you know, someone who has been allowed to use this car and who has a suspended license. That it is reasonable for somebody to have an expectation of privacy under those conditions. And I see my time.
Okay.
Thank you.
We have a big trial, and we have a lot of lawyer services here, and I noticed that Mr. Zirkin and Ms. Carlton and Mr. Dinkin, you were court appointed, and I want to recognize that service. It's so highly important. I think our system can be proud in the world and in world history to know that we provide services like this to our defendants. Of course, I appreciate the services of all lawyers. Our American bar is above all. And so we'll adjourn for the day and come down and greet counsel.